Government Order of the Day number 1.
Marine and Coastal Area Takutai Moana Bill, committee stage continued.
I declare the House... Point of order, John Biscown.
Point of order, Mr Speaker, thank you. You're probably aware, Mr Speaker, that the House sat beyond midnight last night voting on Part 3 of this bill, and during that time the air conditioning to the House was turned off, the lighting in the corridors became darker, and given that the government's intention to proceed on this bill, if the House is sitting beyond 6 o'clock this evening voting on this Part 4, can we have an assurance that there be catering facilities available for the staff and members?
Order. With respect to the matters of the air conditioning and the lighting in the corridors, the matter has been drawn to the attention of Parliamentary Service to try and ensure that doesn't happen again. With respect to the refreshment facilities, there are standard times that there's not a lot I can do about those. I declare the House in committee for further consideration of the Marine and Coastal Area Takutai Moana Bill. Mr Speaker. Mr Chairman.
Members, the House is in committee for the further consideration of the Marine and Coastal Area Takutai Moana Bill. And the question before the members of the House is that Part 4 stand apart.
Mr Chairman.
Call the Honourable Chris Finlayson.
Mr Chairman, Part 4 sets out procedures relating to the recognition of customary interests either by agreement or order of the court, and it deals with some administrative details. The part I particularly want to focus attention on is Subpart 1, which provides the procedure for the recognition of customary interests. It can either be done by recognition by agreement or recognition by the court. The key changes proposed in the SOP focus on the procedure for recognition by agreement. A number of people had made submissions both to the Select Committee and to me personally about a desire for greater transparency. To make any agreement negotiated with the Crown for recognising customary title more transparent, the SOP changes recognition agreements for titles to be brought into effect by an Act of Parliament instead of an Order in Council, and this will allow scrutiny of agreements by members of Parliament at select committees, and it will allow the public some say in the matter. The next point which needs to be addressed is an application for a recognition order, and the matter of principle that people may wish to discuss concerns which court one should apply to. What I've tried to do in the bill is provide really the best of both worlds. So an application will be made to the High Court, but the court may refer to the Maori Appellate Court any question of tikanga. Why the High Court and not the Maori Land Court? Well, I suppose I was very influenced by the history of the Ngāti Apa litigation that began in the Maori Land Court. It went to the Maori Appellate Court, thence to the High Court and then the Court of Appeal, and by leave could have gone to the Privy Council. I'm also very conscious that proceedings both in the Maori Land Court and the Maori Appellate Court are capable of being the subject of applications for judicial review. So if anyone really wanted to delay a matter or oppose a matter down to the wire, the easy thing to do if something had begun in the Maori Land Court was seek judicial review of anything. And so I was very concerned about cost and delay, which is why I have put in the bill that the proceeding commence in the High Court. But as I say, it's the best of both worlds because there can be reference to the Maori Appellate Court for any question of tikanga, and the opinion of the Maori Appellate Court will be binding on the court, and the court may also refer any question of tikanga to an expert. The next point I wish to address is contained in Clause 101, service of the application. This should allay any fears that it's simply going to be a question of an application served on the Crown. Local authorities have to be served, the Solicitor General on behalf of the Attorney General, and importantly any other person who the court considers is likely to be directly affected by the application, and there needs to be public notice of the application. Clause 105 is an important clause, and it's the subject of an amendment in the SOP. This is the burden of proof clause. It's been clarified to ensure that applicant groups are only expected to prove the positive elements in the tests. Some people have complained that shows favouritism to applicants. It does nothing of the sort. The Court of Appeal in the Ngāti Apa case made it very clear, based on Canadian and Australian authority, that the onus of proving extinguishment lies on the Crown, and the necessary purpose must be clear and plain, and those authorities are well established. Subpart 3 deals with regulation-making powers. The only provisions I refer honourable members to for the debate are clauses 118, which provide for the Governor-General by order in Council to make regulations for administrative purposes, and clause 119, regulations may be made for the management of the common marine and coastal area, particularly clause 1A, which provides for regulations for the... Mr Chairman?
Call the Honourable Minister Chris Finlayson.
For the safety and protection of members of the public who exercise rights of access in and over the common marine and coastal area, and prescribes offences, something that is not contained in the 2004 Act. And there is also an amendment which will be proffered in the SOP to provide that any person breaching a regulation or bylaw may be directed to stop. So, Mr Chairman, most of the provisions of this part of the Act are of an administrative nature, but there are some important questions dealing with both recognition by agreement and order of the Court that need to be addressed.
I call the Honourable David Parr.